Now, any attorney looking out for their client's interest and not lining their own pockets with legal fees in a case involving a claim for a strip of property at the earliest possible time is going to provide proof to the adversary, if there is proof, that the claim brought was meritless. If Campagna showed me the 1 or 2 photographs of the fence that were different from the fence present when I commenced the lawsuit, I would have immediately dropped at least that section of the lawsuit. It would have been fruitless for me to waste time. Court time I could have spent on clients' cases, energy and money, including deposition transcripts and aerial photographs from over the 10-year period before. That time and money on a case that was going to be dismissed. But no. Campagna hid these photographs. He hid these photographs when he made a motion to the court for summary judgment. Now, when an attorney makes a motion for summary judgment, he has to put forward all his proof, every last bit of it. Thomas decided to keep even the court from having the irrefutable proof that the fence in 1991 was different from the original fence and property bought by the Gonzalezs. Okay, here's the order of Justice Newmark in the case. And the order was dated August 18th, 1992. And if we look at it, defendant's motion for summary judgment to the plaintiff's fifth cause of action, the adverse possession claim, is denied, as there are triable issues of fact concerning the necessary elements of adverse possession. Now, it should be noted that in the defendant's motion for summary judgment on the adverse possession claim, Campagna was required to give all the proof he had and to the court. And as of August 18th, 1992, a year after my lawsuit was instituted, Campagna withheld that evidence from the court. That evidence being the photos of the post-rail fence that was different from the fence that existed at the time of the lawsuit in 1991. Then there's the court order in the case, dated February 26, 1993, so a year and a half after I commenced the litigation. And in that particular order, the judge indicates my motion for a preliminary injunction to restrain the actions, restrain actions to remove or destroy the plantings is granted, and the defendants, that's the Gonzalezs, are enjoined from removing, unearthing, or otherwise destroying the evergreen, bushes, rose bushes at the vegetation, the disputed strip, and from removing or destroying the fence in its current location, between the parcels, pending final judgment. The courts, in the court's opinions, 3 requisites for such relief: irreparable damage, balance of the equities, and here we go, folks, likelihood of eventual success. Okay? So, once again, Campagna decided that he was going to draw this litigation out. He didn't provide the court a copy of the old fence, a photograph or video of the old fence that he had in his possession, and he had been given in 1991 by his client, Penny Gonzalez. Because if he had, likelihood of eventual success, which the court deemed that I was likely to succeed. Okay, here is the order of Justice Newmark in the case, and it is dated December 21st, 1993, 2 years after the litigation was commenced by me, over 2 years. And if we look at it, we see, let's see, the request by defendants for costs and sanctions pursuant to that is denied. The request by plaintiffs for summary judgment in their favor. Denied. So the defendants had their requests denied. I made a request for sanctions based upon Campagna withholding his the photographs, and that was denied also. And note again, the request by defendants for costs and sanctions is denied at that time. And request for my things for request for sanctions because Campagna refused to turn over the photographs that he had in his possession, which drew out the lawsuit for over 2 years, was denied, despite the fact that I had proof and I submitted it to the court that Campagna had the photographs of the fence in his possession for 2 years and decided he wasn't going to give it to me. And of course, why didn't he give me the sanctions? Because Campagna was a Jew and Judge Newmark was a Jew. You can hide evidence when you're a Jew in New York State because the Jews will protect you. And with respect to the court finding sanctions, it wasn't because of my lawsuit. It was because of one motion that I re-argued. And this is the decision for leveling sanctions in the amount of $1,000. Note the judge didn't level sanctions against Mr. Campagna because he was a Jew. And it says, in the court's view, the utter lack of merit to the instant motion to renew and argue demonstrates the type of misuse of judicial process. Okay? That was it. One motion. One motion was deemed frivolous, not the entire lawsuit.
Wait, a 1997 suspension order found my lawsuit a malicious abuse of legal process. It also found I knowingly filed suit for the sole purpose of harassing and maliciously injuring another. Now, I've already discussed the Johnson case. It's clear I wasn't trying to injure them. So it must be this case, right? The Gonzalez case. Yet Judge Newmark, as you've seen, found the adverse possession part of the case was likely to succeed. Oh, that's right. The original judge order was made before I exposed Thomas Campagna for trying to boost his legal fees by concealing material evidence. Remember, folks, when a Jew is involved in New York State, material facts like whether someone is a Jew or not, or whether there's a photograph of a different fence, they're allowed to be concealed. Now, Campagna concealed the photographs of the old fence because he wanted to unnecessarily prolong the case to boost his legal fees. He gets away with his conduct, and I get suspended for supposedly dragging out a frivolous suit. Once again, what's the reason? It's kind of obvious. Mr. Campagna is a Jew. The majority of people involved in my suspension were also Jews. Now, the adverse possession claim and notice of pendency I filed against the Gonzalez's after a dismissal in the Gonzalez's favor, which did happen, under New York state law normally would have made me liable for the entire cost of the litigation. But due to Campagna's complicity in delaying the case and perpetrating a fraud on the court, and the possible conspiracy of the Gonzalez's with Campagna in the purposeful act of his withholding evidence which delayed the case, there was no way a civil court was going to get away with rewarding Campagna for his actions. Now, suspending an attorney wrongfully is not news. Who cares? Just ask Bruce Cutler. But an attorney getting rich from withholding evidence, now that's newsworthy. So, in order to save face with Penny Gonzalez and not to have to explain to her that his conduct was wrong, an attorney from Campagna's office filed a lawsuit against me and my ex-wife 16 days too late. And as a result, Campagna's concealing evidence in the 1991 case never became an issue. The court dismissed the case based upon the failure to bring the action within 1 year. Case closed. What Campagna most likely did was reimburse his clients for any money they paid him and told them to be satisfied with taking away my livelihood.
This is the decision and the dismissal of the case against the Gonzalez's against me and my ex-wife, although, let's see, and that was, it's 1995. It's by the same judge. It's dated May 23rd, 1995. Let's see. And it indicates, let's see, who was the plaintiff's attorney? Indicates the plaintiff's attorney was Campagna and Langella. Even though it was somebody else, one of their associates who put their name on the complaint. And it indicates they had two causes of action: malicious prosecution and abusive process. 1 year statute of limitations. And the judge indicates the limitations period was not told by the appeal, that the Gonzalez's complaint was dismissed as time barred.
As an aside, on that fateful Memorial Day weekend in 1991, it was my ex-wife who originally went over to the Gonzalez's front door, and demanded they should lower their radio. And that set the whole thing rolling. It's in the depositions of all parties concerned.